the defense, cannot lecture me on humility. If there's somebody who needs to be reminded about humility, it's them, the defense.
The chair hereby strictly enjoins all persons covered by Rule 18. You know who you are, and based on the records, we know who you are.
What's up mga kababayan? ph.trending here. Dito sa video natin ngayon na ating panoorin itong Day 19 impeachment trial ni VP Sara. Sadyang makapal ang pagmumukha nitong si Atty. Armando Ligutan, no? Matapos pagsabihan nga ng defense team na iwasan ang mga salitang pamumulitika sa loob ng korte. Ngunit matapang na dinipensa nito ni Atty. Ligutan at ang kanyang mga controversial na social media posts. Sa kanyang talumpati mga kababayan, iginiit pa niya na hindi siya pwedeng pangaralan ng defense panel pagdating sa pagkakaroon ng kababaang loob. Na di umano, dapat ang defense team ang nararapat matuto nito at magpakita ng pagpapakumbaba. Grabe naman yan. Kung kaya naman hindi maiwasan mag-comment nitong si Presiding Officer Chiz sa mga abogado na nagbabala nga ito at kanyang sinabi na you know who you are and based on the records, we know who you are. Kung kaya naman laking patama nito dito kay Atty. Ligutan at sa mga kasama pa niyang abogado dito sa impeachment trial. Buti nga sa kanila. Pero bago ang lahat, huwag niyo po sana kalimutang mag-like at subscribe para updated ka sa mga uploads ko araw-araw. At yun na nga mga kababayan, pinaalalahanan din ni Sanchez Escudero ang mga senator judges na maging impartial at politically neutral sa gitna ng impeachment trial ni VP Sara. Sinabihan din niya ang mga ito na sila ang tanging witness at idirekta ang kanilang mga tanong dito sa korte at iwasan ang pamumulitika sa social media na pwedeng mauwi sa ethics complaint o anumang paglabag. Kung kaya naman hindi ko na patatagalin pa, heto na ang buong video.
For his hopefully brief reply, yes, Attorney Boa.
Just before we give Attorney Ligutan his time, Your Honor, just wanted to make a quick manifestation. It was just brought to our attention yesterday that after the proceedings that we had yesterday, that an interview was given wherein I think what was discussed yesterday about the word scam, etc., was repeated during an interview. Now, while it may have been stated in a matter that's sort of a matter-of-factly, we do hope that this will be included in the ruling of the Honorable Presiding Officer.
It
At
is
least for
included,
guidance, Your
actually,
Honor.
Attorney Boa.
Thank you, Your Honor.
Yes, Attorney Ligutan.
Hello? It's working. Hello?
You are recognized, sir. You may proceed when you're ready. With respect
so
to
much.
your, shall
It's
I call
brief.
it, counter-manifestation.
It is brief, Your Honor.
Thank you, Attorney Ligutan. You may proceed.
A teacher, a lawyer, a rule on cross-examination, a Facebook post. How did we get here? Last August 12, before trial was adjourned, it was a Wednesday. Out of the blue, the defense made a manifestation, or should I say, a big issue of my Facebook post earlier that morning. My post reads, a principle all lawyers and law students know by heart. Misleading questions are not allowed, even on cross-examination. Period. The defense surmised it is a reaction to that viral exchange between the opposing counsel that morning. A lawyer for the defense said, in effect, that misleading questions are allowed. We all heard it. It immediately caused an uproar on social media, especially in the legal community where it is a well-entrenched rule that misleading questions are not allowed, even on cross-examination. It is a truism as irrefutable as the sun rising in the east and setting in the west. It is a principle all lawyers and law students should know by heart. But why post it on Facebook? Your Honors, why not? Yes, I am a lawyer. But more than just a lawyer, first and foremost, I am a teacher. Isa po akong guro. Usa ko kang maestro, and I'm proud to be one. I have been a lawyer for almost 16 years, but I have been a teacher, an educator for almost 20. At alam ng ating mga magigiting na guro sa buong kapuluan na ang pagtuturo ay likas sa ating mga guro. Ang pagtuturo, ang pagtatama ng mali, ay walang pinipiling lugar at walang pinipiling panahon. That's why I made that post. I was concerned that the statement made in open court that misleading questions are allowed will go unchecked. My teacher's instinct kicked in. I wanted the students I left in Cebu, especially in the University of San Jose Recoleto School of Law, where I have been teaching for the past 15 years, and recently in the University of Cebu School of Law, and in Diliman, my alma mater, the University of the Philippines College of Law, and all law students out there. I want them to know that a teacher had heard that wrong statement in open court, and he is correcting that mistake on Facebook, as I have been doing the past years. To the defense, I shall not name names. I will not put you on the spot. But the post is not about you. It's not personal. It is about the law that we all adhere to. It is about what we teach the public who are watching our trial. Correcting a mistake is never wrong. Doing it while a hearing is ongoing online does not make it not right. Ang pagtatama ng mali ay kailanman hindi ipinagbabawal kahit sa loob ng impeachment court ito. Now the defense said they found it troubling or in bad taste for a prosecution lawyer like me to, quote, do this, unquote, in the middle of a courtroom hearing. But do what? Correct a wrong? On the contrary, Your Honors, what is more troubling is for the defense not to admit their mistake and instead call out a lawyer, a teacher who just stated what is correct in his own time and in his own Facebook account. What is troubling is if we turn a correction of a mistake by one side into a shield from fair criticism for the other. Now the defense is asking this court to act on my post. It is elevating it to a serious courtroom violation. But what did I violate? I did not discuss the merits of the case. I did not discuss the strength or the weakness of the oral arguments or evidence of either side. I only stated, without mentioning any name, using the most neutral of font color and background, black and gray, without adding any emoticon, without splicing anything. What the rules of procedure simply provide, that misleading questions are not allowed, even on cross-examination. Your Honors, we in the prosecution also have rights. I, for one, did not surrender my freedom to teach and to enlighten when I decided to participate in this trial. Patuloy po ako magiging guro kahit sa loob ng impeachment court na ito. Lastly, Your Honors, the defense mentioned humility, that I should have been humble enough not to post that now viral statement. Your Honors, being a provinciano from Leyte, Samar, and Cebu, and coming from a middle-income family born without a famous family name, who had to compete for his spot in this capital, I know a thing or two about humility. The defense cannot lecture me on humility. If there's somebody who needs to be reminded about humility, it's them, the defense. It is the opposite of humility. It is pride, not to admit a mistake, or worse, call out someone who simply corrected that mistake. Good morning.
That does not fall under my definition of brief, counsel, but we will take it nevertheless. For the record, before the chair makes its ruling on these matters, the TSN says, Attorney Kapunan, leading, and then she corrected herself, misleading questions are not allowed on cross. Attorney Ferrer, she said they are allowed. Now, the TSN cannot possibly cover the overlapping voices, if at all. So most likely what happened, although we will check the video, would be Attorney Ferrer commenting on the earlier statement that was corrected later on by Attorney Kapunan and changed leading to misleading. Perhaps Attorney Ferrer was referring to leading questions and not misleading questions. But having said that, nevertheless, the court will include that as part of its ruling, with one caveat, Attorney Ligutan. While you do not remove your hat as a teacher wherever you go, the same is true with this representation. I had my fair share of teaching as well. Under the rules of the Senate, unfortunately, you have to unbundle it. You have to decouple it. Under the rules of the Senate, if you are counsel for the parties, you cannot comment on the merits outside of a fair and true report of what happened. In this case, based on the TSN, I am not sure of the accuracy, given that the statements made were pertain to both leading and misleading questions. Number two, it still does not take away, your being a teacher, does not take away your responsibility under the CIPRA to a fellow lawyer who you are jousting with or arguing with or competing against this impeachment court. The remarks of the good gentleman, the Attorney Ligutan, the counsel for the panel of prosecutors, is noted and it will be entered into records. Thank you, sir. Chair will now make its ruling with the permission of the body from the rostrum, because it's difficult to read while sitting down a long ruling. You may sit down, Attorney Chua, for a bit. This will take some time. With the permission of the Senator Judges. The Chair wishes to address certain matters as it is necessary to protect the integrity of this trial. It has come to the Chair's attention over time that public statements attributed to persons covered by the rules on impeachment, whether made in interviews or in social media, appear to concern the evidence, the credibility of witnesses, and issues pending before this court, which may fall within the prohibition under Rule 18 of this court. Although the immediate matter arose from statements and conduct involving respective counsel last August 12, it raises broader concerns affecting the impartiality, decorum, and integrity of the impeachment court. Before imposing or enforcing standards of restraint upon the parties and their own counsel, the court must first look inward and put its own house in order. The chair shall therefore resolve these matters in three parts. First, the duties of impartiality and decorum incumbent upon senator judges. Second, the scope, coverage, and prospective enforcement of Rule 18. Third, the specific guidelines governing compliance with Rule 18. First, senator judges' impartiality, decorum, and the internal remedy. The chair begins where institutional discipline must always begin, with the court itself. The restraint, impartiality, and decorum demanded of the parties and their counsel must first be exemplified by those who sit in judgment. As senator judges, let us keep in mind our oath, quote, to do impartial justice according to the Constitution and the laws of the Philippines, close quotations. And the requirement under Rule 3 of the Rules of Impeachment to observe political neutrality therein defined as, quote, the exercise of a public's official duty without unfair discrimination and regardless of party affiliation or preference. The chair likewise cites the relevant provisions of the 2025 Code of Judicial Conduct and Accountability, or CIPRA, on impartiality and the sub judice rule. Canon 3, Section 10 provides, quote, during the pendency of a case, a judge shall not knowingly make any comment in and out of court that could reasonably be expected or perceived to affect its outcome, impair the fairness of the process, or diminish the public's confidence in the court's impartiality. Canon 4, Section 24 provides, quote, a judge shall not engage or use any form of expression which tends to violate or has the effect of violating the sub judice principle, provoke or inflame divisive and contentious issues of public concern, or project an image not compatible with the dignity of their position. Taken as a whole, these principles remind us of our duty to preserve the impartiality of this court and the fairness of these proceedings. As the court said in People v. Court of Appeals, GR number 118882, this court has repeatedly and consistently demanded, quote, the cold neutrality of an impartial judge as the indispensable imperative of due process. Judicial proceedings are not orchestrated plays in which the parties are supposed to make motions and reach the denouncement according to a prepared script. There is no writer to foreordain the ending. Close quotation. Also in Berso versus Rabe, AM number RT 21010, a judge must not only be impartial, but must also appear to be impartial, as an added assurance to the parties that his decision will be just. Litigants are entitled to no less than that. For avoidance of doubt, this shall not prevent senator judges from examining the evidence where the examination belongs during the proceedings and on the record. The Supreme Court in People v. Gambor, GR 152183, said, the trial judge is accorded a reasonable leeway in putting such questions to witnesses as may be essential to elicit relevant facts, to make the record speak the truth. A judge may examine or cross-examine a witness. He may propound questions to test the credibility of the witness and to extract the truth. He may seek to draw out relevant and material testimony, though that testimony may tend to support or rebut the position taken by one or the other party. It cannot be taken against him if the clarificatory questions he propounds happen to reveal certain truths which tend to destroy the theory of one party. Taken together, Rule 17 and the Gambor case confirm that a searching question is not partial merely because the answer may aid one side or weaken the other. The prosecution and the respondent's counsel must be prepared to answer such questions. The inquiry must remain relevant, material, fair, and directed toward clarification of truth. It must not devolve into a speech, harassment, partisan advocacy, or an announcement of a conclusion already reached. The line is clear. Senator judges may test the evidence here under oath and on the record, exercising the cold neutrality of an impartial judge. When constituted as an impeachment court, the Senate does not cast aside the discipline of parliamentary practice, except where the specific rules on impeachment or the adjudicative nature of these proceedings require otherwise. The rules of the Senate established parliamentary precedents and courtesies of the chamber continue to bind every member sitting as senator judge under Rule 34, Sections 93 and 94 of the Rules of the Senate. Deem acts or language that offend a senator or any public institution or third party to be unparliamentary and prohibit the use of offensive and improper language against another senator or public institution or third party. Henceforth, I hope senator judges shall refrain from unparliamentary remarks, personal attacks, imputations of improper motive, and other language incompatible with the dignity of these proceedings and of parliamentary courtesy to other people. The chair will at all times extend to his fellow senator judges the courtesy befitting equals and reasonable latitude that serious deliberation requires. Differences in judgments and vigor in debate are to be expected and shall, as far as practicable, be met with patience, flexibility, and respect. Should circumstance so require, however, the chair will not hesitate to enforce the rules of this impeachment court, the rules of the Senate, particularly sections 95 and 96. In this chamber, firmness need not be unkind, nor courtesy come at the expense of duty. Both serve the same end, the fair and honorable administration of justice. Further, where a senator judge is alleged to have violated the impeachment oath, Rule 3, Rule 18, or any other applicable rule of the Senate, an available institutional remedy within the Senate is the filing or referral of an ethics complaint to the Senate Committee on Ethics and Privileges in accordance with the internal rules of the Senate. Under Rule 10, Section 1316 of the Rules of the Senate, the Committee on Ethics has jurisdiction over all matters relating to the conduct, rights, privileges, safety, dignity, integrity, and reputation of the Senate and its members. Any disciplinary action remains for the Senate to determine under Article 6, Section 16.3 of the Constitution and applicable rules. This shall not be a proper subject matter to be taken up within this impeachment court so as not to divert the attention from the impeachment trial against the respondent in this case. Accordingly, the chair reminds all senator judges, first, to observe the impartiality and political neutrality required by their oath and the rules. Second, to observe the parliamentary rules, precedents, and courtesies of the Senate and refrain from unparliamentary, offensive, or improper remarks. Third, to exercise their authority under Rule 17 to question witnesses, prosecutors, and counsels for the respondent and the prosecutor during the proceedings on the record instead of through commentaries in social media. Second ruling, Rule 18, scope, coverage, and prospective enforcement. Note on the statement, prospective enforcement. Having addressed the conduct expected of senator judges, the chair now turns to Rule 18 and the persons expressly covered by it. The chair makes this ruling not only in response to the manifestation and motion made by counsel for the respondent, Attorney Sheila Season, on August 12, and after due consideration of Attorney Ligutan's explanation, but also on the basis of the chair's independent findings of seeming violations of Rule 18. These incidents come after the chair's earlier advice to both panels to designate the respective spokespersons so that the necessary and appropriate communications may be made within the limits prescribed by the rules. Since that advice has not been fully observed, the chair now finds it necessary to restate and strictly enforce those restrictions. Article 18 of the Rules on Impeachment provides, the presiding officer, the members of the Senate, shall refrain from making any comments and disclosures in public pertaining to the merits of a pending impeachment trial. The same shall likewise apply to the prosecutors, the person impeached, and their respective counsel and witnesses. This rule exists to balance the public's right to information on matters of public concern with the need to protect the integrity of the proceedings from public prejudgment. The rules of court apply only suppletorily to these proceedings. When the rules on impeachment expressly and specifically govern a matter, they control. Since Rule 18 directly governs public comments and disclosures pertaining to the merits of the pending impeachment trial, it is for this court, in the exercise of its authority and sound discretion, to determine whether a particular statement violates that rule. Henceforth, with respect to prior statements or conduct covered by Rule 18, the court shall extend grace, exercise liberality, and wipe the slate clean, tabula rasa, so to speak. From this point forward, however, Rule 18 shall be strictly enforced and be given full force and effect. Accordingly, the chair hereby strictly enjoins all persons covered by Rule 18. You know who you are, and based on the records, we know who you are. And that the only way for this court to obtain an acquittal, and that is the only way for this court to obtain an acquittal from the bar of public opinion. That obligation rests upon every senator judge to decide solely upon the record, under the Constitution and under our rules, and in a manner worthy of the confidence of the people to whom this court is ultimately accountable. Thank you, and we may proceed with the trial at hand. Sorry, ma'am.
Your Honor.
Before recognizing the Honorable Chua, Chair would like to instruct the Clerk of Court through the OSA to kindly situate Mr. Ortonio to the witness stand. Yes, Honorable Chua.
Your Honor, may I now turn over to the counsel for the prosecution, Attorney May Divina Gracia.
Attorney May is recognized, and also, before recognizing Attorney Christine,
We will just ask for Attorney Christine Ferrer to be recognized, Your Honor.
yes, Attorney
Thank you.
Christine and Attorney May then. Ginoong Ortonio, kayo po ay patuloy na tetestigo sa ilalim ng nauna niyong panunumpa po. Kung saan nanumpa kayo magsasabi ng katotohanan at pawang katotohanan lamang. Naunawaan po niyan?
Yes po, Your Honor.
We may proceed now with cross. Attorney Christine, you ready?
Your Honor, if I may be recognized.
Yes, Attorney May.
Your Honor, before the defense counsel proceeds with their cross-examination, the prosecution respectfully moves that the defense be directed to conduct its cross-examination in a non-leading question form, Your Honor. Yesterday, Your Honor, this honorable court declared Mr. Ortonio a hostile witness pursuant to Rule 132, Section 13 of the Rules of Court. And in so ruling, effectively, this honorable court also declared that the interest of this witness is aligned with the respondent. Now, Your Honor, the permission to conduct the permission to propound leading questions on cross-examination under Rule 132, Section 10A of the Rules of Court rests solely on the presumption that the interest of the witness to be cross-examined is hostile or is adverse to the cross-examiner, making it difficult for the cross-examiner to put into the mouth of the witness words that he expect to be elicited. Now that presumption, Your Honor, has already been overcome by the declaration of this honorable court. So what we expect, Your Honor, is merely cross-examination in form but not in substance. Because in substance, Your Honor, the cross-examination would effectively be like the respondent herself cross-examining, the respondent cross-examining or direct examining, conducting a direct examination of her very own Assistant Chief of Staff. Last Monday, Your Honor, we witnessed how the defense, under the guise of cross-examination, supplying testimonies to the witness, Ms. Gina Acosta, and merely expecting her to supply yes to each and every question, Your Honor. And that is the very evil sought to be prevented by the rule against leading questions on direct examination. Your Honor, I understand before I'm lectured on the contents of the rules of court, I'm very much aware of what the rules of court provide. But I'm also very much aware, Your Honor, that under the rules of this honorable court, the rules of court is merely suppletory in application. And in fact, the presiding officer is granted leeway to rule on every matter of evidence.
Comment, Attorney Christine.
Yes, Your Honor. Rule 132 of the Rules of Court does not convert a hostile witness into as our own witness, Your Honor. So, therefore, we are not obliged to ask direct examination questions, Your Honor. Thank you.
If I may, Your Honor.
Short reply, and in so replying, Attorney May, kindly cite a legal basis outside of the rules of court, since you said it's not in the rules of court.
Your Honor, I'm citing the very own rules of this honorable court, saying that the rules of court is merely suppletory in application, and at the end of the day, it will be the presiding officer who will be deciding on matters of evidence. And early in the proceedings, Your Honor, if I remember correctly, 2 senator judges encouraged this honorable court to look beyond the wordings of the law and consider the intent for its application.
That it, Attorney May?
Yes, Your Honor.
Chair will make a ruling. Rules of court, although it has merely supplementary application to these rules, nevertheless do apply. And the rules of court state specifically that leading questions may be asked on cross-examination without any exception nor any limitation. And as held in the Bolos case, there is no need to interpret the rules in case where there is no doubt, and the rule is quite specifically clear. Number 2, we already have a precedent, at least with respect to the previous witness declared as a hostile witness in the person of Gina Acosta, where the court allowed counsel for the respondent to ask leading questions. You shall be accorded the same privilege, Attorney May, on the part of the prosecution, should the respondent rather present a hostile witness during the presentation of their evidence in chief. The court shall apply the rule equally. So ordered.
Thank you, Your Honor.
You may proceed, Attorney May, or rather Attorney Christine.
Yes, Your Honor.
When you're ready.
Yes, Your Honor. Before I start with my cross-examination, just to put the record straight, Your Honor, when I said they are allowed, I was referring to leading questions, Your Honor, because the journal dated August 12, 2019 would show that I was indeed asking a leading question before Attorney Kapunan objected, Your Honor. So if we take a look at it, with all due respect, the objection was even improper at that time, Your Honor. So, but I want that issue to be closed.
That was similarly pointed out by the presiding officer, counsel.
Thank you, Your Honor.
Sorry, Your Honor, before I proceed, may my colleague be recognized, Your Honor, Attorney Kapunan?
Of course. Attorney Lorna.
Your Honor, please, first of all, I'd like to commend the presiding justice. Very clear. The ruling on sub judice is very clear, and we will take it with strict compliance, Your Honor.
Thank you, counsel.
I'd like to manifest, though, that, again, the statement of counsel is misleading because it was very clear. It was very clear, and the transcripts will show that the immediate phrase which led to my remark was not about leading, it was about misleading, Your Honor. If I heard it, if the whole legal profession heard it, if this courtroom heard it, if the outside audience heard it, then it must be, it is what it is. She had said misleading is allowed, and I responded to that, and I'd like that to be on record, Your Honor. Let us not mislead again this honorable court. Thank you.
Your Honor,
The chair already made a ruling earlier regarding this matter brought about by the lead counsel. In lieu of that, the chair will simply furnish the parties with a copy of the TSN, wherein, I will quote again for the record, for the last time, and then we proceed with cross. It's already 11. Attorney Kapunan, leading, misleading questions are not allowed on cross. Attorney Ferrer, they are allowed. This is what the transcript says, and it has no reference to Attorney Ferrer stating specifically that misleading questions are allowed. And perhaps the confusion arose with respect to the TSN, again, not being able to capture the perhaps overlapping statements made by both counsels, and we should leave it at that already, counsels, and move on.
Thank you, Your Honor.
So, when you're ready, no more manifestations, Attorney Christine.
None, Your Honor. We will
Proceed to cross.
Yes, proceed to cross.
Attorney May, you shall be the counsel for the prosecution.
Yes, Your Honor.